what way has General Masemola, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption? Surely that cannot be suggested, I do not think. Same place, same time, about the same place, same time as the commission of the fraud and corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemola was wrongly lumped with these other people. You must accept.
The argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud, admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was it, what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as he's concerned? Remember, you just said, in response to my last question, you just said evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So
I was giving you the discussions that we had,
which were wrong ultimately. You accept that?
I see that.
You certainly must. Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that General Masemola has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily. You know these principles. You apply these sections all the time. Why was this done? Why was Commissioner Masemola lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there, people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemola. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that you've already accepted that in any event, General Masemola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemola is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to what I suggested to you now?
And I wanted to say that because of, if you read 157,
yes.
that becomes a bit more, is more appropriate then in the circumstances and given the jurisprudence.
Yes. But you basically agree with me, you've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Yes, thank you, Chair. Good morning, Advocate Johnson.
Good morning, Commissioner.
I'm going to deal with process leading to the charges by IDAC. So the Section 27 affidavit or
Sorry,
additional...
Chair, I think sorry, Commissioner Khumalo, I don't know if the Chair found his file. It was you got file 9. Sorry.
Yesterday already I did. Thank you very much, Advocate Johnson.
In your response to Chair, you referred to General Matlala's affidavit. So if you look at General Matlala's affidavit starting on 3519, what she says in 3520 in relation to General Masemola is that, so first of all, she's the head of risk and integrity, so head of risk and compliance at SAPS. And she would have investigated these issues, as I'm sure her job description requires her to. And then she says in paragraph 8 on 3520, she then advised General Masemola to consider terminating the contract with Medicare to save subs from irreparable harm and to diminish the financial prejudice suffered by subs. Then she says General Masemola terminated. So General Masemola accepted the advice. Do you see that?
Yes.
Now, if you read section 86 of PFMA with section 38, what it requires is willful and grossly negligent conduct on the part of General Masemola. As I understand those two sections, they would kick in if, notwithstanding the advice by the head of risk and compliance, he does absolutely nothing. Because then that would be willful and grossly negligent. But if your head of risk says, I've investigated this, here is an audit report that shows that at the time when you did not know, some members of SAPS in supply chain were colluding with Mr. Matlala's company. And as a result, this contract was concluded. They were also colluding in relation to the issue of, I think it's in charge 3, of the orders, of the purchase orders, which is not something that as a commissioner you would generally know because it happens at supply chain level. If now head of risk investigates, gives you an audit report and says, the purchase order process and even the granting of the contract from the beginning were tainted by criminality. You as accounting officer, you come in at that level and you say, now that I have all this information, what do I do with it? And if upon receiving that advice, you terminate the contract, where is the willful, intentional conduct and the grossly negligent? Because the way these charges are formulated, IDAC is basically saying from the date the tender was awarded, because they say from May 2024 until May 2025. So they say from the date the tender was awarded, already there was willfulness and grossly negligent conduct on the part of General Masemola. But that cannot be if you look at the issue of the purchase orders, for example, in count 2. Those only started coming in after the tender was awarded. And payments only happened after services were rendered. So it cannot be that from the 8th of May already, because there was no tender on the 8th of May. The service provider was appointed in June, and after they were appointed, we've had evidence that there were then meetings about how the contract is going to be implemented. And the contract was then implemented much later, from September onwards, if I remember Brigadier Macheng's evidence correctly. So it's not clear to me how in May, June, July, August, PFMA breaches could have occurred on the part of General Masemola. So do you see where I'm going? That you can only sustain the PFMA charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if, after he has received advice from the head of risk, he ignores that advice and allows subs to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
yes,
General Matlala, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand it.
Do you accept that like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act, because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if, after he has received advice from the head of risk, he ignores that advice and allows subs to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
Yes.
General Matlo, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand it.
Do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlo's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion by, if General Matlo is the complainant, there's no suggestion by General Matlo that General Masemola did nothing with my advice or he took inordinately long before acting on that advice. And
was that, well, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here. With a lawyer's eye, and that it doesn't find expression suggests to me is because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct, and for that you couldn't go that far. But it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloy, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality. And as I explained this morning, it relates to I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did.